Mr. Emery.
Good afternoon, my lord, my ladies. I was proposing to commence now with the topic of estoppel, and I deal with this in my written case, starting on page 21. I wonder if that could be turned up, please.
There's page?
21.
Yep. That's MS 1626.
Ground 3 is estoppel. At paragraph 35, I set out the arguments made on appeal by my opponents.
Yep.
And in the paragraphs which follow, I deal with each of those arguments. And I wish to start the discussion on estoppel at paragraph 39, which appears under the heading estoppel not pleaded, the complaint being made that this was not the subject of the proceedings in the Grand Court. Now, I'd just like to read out paragraph 39 before we turn to the documents. The respondent's statement of claim relied upon the second notice dated 10 July 2014 as the basis on which it exercised its option. In response to that pleading, the defence alleged that VDM had failed to comply with what was said to be a specified timetable for the exercise of the option contained within the body of the first notice, the one that had been served in October 2013. It was also pleaded by the appellants that VDM had affirmed the agreement for sale containing the option clause without fixing by agreement with the appellants a new date by which they ought to have commenced and or completed construction of a residence on the property. In other words, the appellants claimed to have been released from their obligations to commence and complete construction within any time as a result of the content of the first notice and the conduct of VDM after it was served. So that's how the issue was framed in the pleadings before the Grand Court. And to demonstrate the importance of the plea by the appellants of affirmation, could I ask the board to go to bundle 3, to the re-amended defence and counterclaim, which appears at page 677. And to make it clear, there was a defence and counterclaim. Following the release of the ruling in Cavendish, there was an amended defence and counterclaim. And then at trial, there was a re-amended defence and counterclaim, and we are looking at the final version, the re-amended defence and counterclaim. If my lords, my ladies, could turn please to paragraph 13.2, which appears on page 680. And this was the defence stating, if which is denied, a valid and enforceable option to repurchase the property had been created by the agreement for sale as amended by the deed, by the date of the purported exercise of the alleged option, that being the 10th of July. Such option had lapsed since. We could ignore 13.21 and .22. You'll see at 13.23 there's a crossed out reference to service. Now what that was that even though the appellants had received service of the notices on multiple occasions, they denied service up until the night before the trial. And so there was an issue as to whether they had received any of the notices to constitute service. Then this point was added. The plaintiff failed to comply with the timetable specified for the exercise of the option in its notice dated the 14th of October 2013. That's the first notice. And we can go down to paragraph 16 on page 681.
Why are we, I mean, this is just to show that your point came up late and you then plead estoppel. I mean, is it, do we need to spend a long time on it?
Thank you, my
You
lord.
set it all out in your case, haven't you?
Yes, I just make the very quick point that it's at paragraph 16 that the plea in response to the notice is made. And the allegation is that with full knowledge of its legal rights, VDM acknowledged the facts giving rise to the breach, affirmed the contract without fixing a new date, and then went on to particularise why it had said, why the appellants were saying that that had happened. So as we went to trial, the suggestion made by the appellants was that even if the first notices had been served properly, the conduct after receipt of the notice amounted to the affirmation of the agreement without the obligation to commence or complete construction at any particular time in the future. And it was in response to that pleading that the reply, or the reply was amended. And one sees the reply at page 686. And in 3.1, on page 686, we set out the response to the allegation that the plaintiff had not exercised its rights in a timely manner. We plead the clause setting out that where the deed is inconsistent with the agreement, it's the provisions of the deed which prevail. We set out the waiver or variation clause at 4.2 of the deed, which is in paragraph 3.2. We then set out our response to the delay and the suggestion that the contract was affirmed by conduct after receipt of the first notice. And that is the pleading of estoppel that appears in 3.4. In the premises, the defendants cannot take advantage of the plaintiff's good faith forbearance and are stopped relying on any such delay as a means to avoid the enforcement of the agreement. And the particulars of the forbearance are then set out in some detail.
It's set out in full in your case.
Thank you. That is right.
We've read your case.
Thank you. Then, what follows in both the case and the reply is an exposition of the communications which took place before and after the service of the first notice. And it was our position that the evidence demonstrated an agreement or understanding or assumption between the parties that the first notice was not being treated as an effective notice. And instead, the parties had agreed that the appellants would have the opportunity to demonstrate that they were in a position to commence construction very quickly and that they had the financial resources to do so, the wherewithal. Now, it was that set of particulars and the contemporaneous communications around it which was the focus of cross-examination to meet the defence that after the 14th of October, VDM had affirmed the contract without setting a new date for completion. When we got to the end of the evidence, having explored that question, the appellants abandoned that defence. So the affirmation point, having been pleaded and addressed in this manner, was then abandoned during my learned friend Mr. Robinson's closing submissions.
Is that what you're referring to at paragraph 50.3? Or is that something else?
No. 50 point... .3 is in relation to a different point. I thought we had mentioned, and I'll just find it. We had mentioned the abandonment of the affirmation point. It is referred to in the Grand Court's ruling, and it is captured in the transcript of the Grand Court's appeal, and I will obtain the reference for that. So,
could I just ask you, where is the reference to 50.3, the statement by the appellant's leading counsel? Where was that made?
yes, I'll find that. It's in the Court of Appeal transcript, which is at bundle 1.
Perhaps you could let me have it at a later.
Yes, I was going to come back to the Court of Appeal transcript, but Mrs. Freeman will locate that for us. So, the complaint taken against me this morning was along the lines of, one of the complaints taken is there was no cross-examination on the issue of an estoppel, as that point was addressed and dealt with by the Court of Appeal. The answer to that is because it wasn't the subject of any pleadings in the Grand Court. However, what we can see from the correspondence referred to in the particulars is exactly what happened between the parties shortly prior to and then immediately after the service of the first notice. And if my lords, my ladies could turn to page 743 of bundle 3 of the reproduced record. This picks up just after the point I stopped at this morning. I'd stopped at page 741. I'd made the point that it was clear by July 2013 that the development was becoming close to being built out, and that Vista Del Mar was looking very carefully at who remained. What appears at 743 is an email dated the 2nd of October indicating that due to a failure to commence construction within 24 months of the date of purchase, Vista Del Mar are considering exercising their rights under clause 6.2 and reminding, this is the second paragraph, notwithstanding your several communications of your intention to commence construction, Vista Del Mar is entitled to require you to sell the property back to them, and you please let us know if you are able to commence construction immediately, so the directors can consider their options accordingly. And what follows over the page is an email from the appellants to Mr. Doak, which we looked at earlier. My ladies, note that the appellants were telling their architect that an update was required and that the appellants appreciated that Vista Del Mar wished to preserve its rights. There followed, on the morning of the 14th of October, a long email which appears at 745 from Ms. Francis to Mr. Joseph, explaining that they did wish to commence construction, that steps were continuing, that they had sought to honour the agreement, and to assure Vista Del Mar of our intention to continue in good faith. I confirm that not only do we intend to commence construction, but we are well on the way to commencing construction. We are actively chasing our providers to provide their respective contributions. But that was not accepted because on page 747, the first notice is served. The first notice, dated the 14th of October 2013, refers to previous correspondence and recent correspondence with Mr. Joseph, and states that pursuant to clause 6.2 of the agreement as varied, you had until the 9th of January 2012 to commence the construction of a residence. I accept that it does not go further and completely quote the wording of the clause. In my respectful submission, that does not affect the validity of the notice. In the fourth to last paragraph appears the sentence, VDM wishes to effect transfer of the land within 30 days of the letter. And the penultimate paragraph says, it refers to the provision of a form of transfer. We will also be in contact shortly to arrange for the completion of the repurchase of the land. So that's the first notice, and the appellants suggested in the Court of Appeal that the effect, what they suggested in the Grand Court, first of all, was that the failure to effect transfer within 30 days meant that we had missed the opportunity to do so. That was their first argument. And our response to that is no, this refers to the wish to effect transfer. That was not the imposition of a strict date. And in any event, one must look at what happened next. But I place some significance on the penultimate sentence, being in contact to arrange shortly for the completion of the repurchase of the land. That indicates that there were to be further communications about the manner in which the repurchase was to take place. Because in addition to paying the purchase price, VDM would also have to pay for the value of any construction works incurred. And so would need to know whether a claim was being made for such construction works and how that would affect the price to be paid. In fact, a counterclaim was made for construction works, but was not followed through and was abandoned. So we say that the meaning of this letter, and I'll come on to deal with the issue of whether that amounts to the acceptance of an offer for sale and a change in the nature of the relationship. The meaning of this letter was not to achieve that, we say. It was to indicate the intention to complete things within 30 days and that further contact would take place. One of the reasons for that further contact we would submit is to try to reach agreement on the form of the transfer. Because as we will see, Vista Del Mar had enforced this very clause against other purchasers, and in doing so had achieved a deed by which all rights were released under the agreements for sale, and the property was reconveyed for the purchase price plus the value of any construction works. So this, we submit, is clearly a reference to what had to come next, which was an agreement on the form of release from the contract and transfer of the property. What actually happened is over the page. On the 30th of October, Miss Francis wrote a very long letter which the board may wish to read for itself if it hasn't done so already. This is the subject of much of the cross-examination which took place and is recorded in the Grand Court's transcript. It records the appellant's shock at receiving the letter, given the progress made to discuss the plans for redevelopment. That is the fourth paragraph. It sets out what had happened in the very recent future, in October, the correspondence we've just looked at. And then it says, after point number 3, in the next paragraph, since receiving the Maples letter, we've contacted Mr. Joseph by telephone to discuss the contents. It is our understanding that the directors will be on island on the 4th and 5th of November. In light of the nature of the Maples letter, we are kindly requesting a meeting with the directors to discuss the position, better outline the progress made this far and provide an update of the schedule. And it goes on to talk about the architects and the communication with Mr. Doak. It explains in the next paragraph that people have been travelling and off island, and in the last paragraph on page 749, it requests favourable consideration of the request and a meeting. The meeting duly took place, and we say that that immediate response by the end of October to the first notice makes it clear that what has happened or is about to happen is an agreement, assumption and understanding that the first notice is to be put on hold so that the appellants can produce their updated schedule and explain and seek the continued forbearance of Vista Del Mar to enforcing the option. Now, several things are going on in the background. One is that in order to take forward that discussion, of course, the appellants require some demonstration from their architects and their contractors that they are in a position to commence construction. And so a number of the letters which follow relate back to the project and the developments, and that becomes important in a moment. But in the meantime, one can see at page 756 a reference to a meeting and a schedule, and that is from Vista Del Mar to the appellants, and also the reference at page 757 on the 10th of January, shortly after the meeting which has taken place, that refers to a fruitful discussion. We were grateful to have John's representation of your situation, which was met with understanding. We've informed John that you will be letting us have a detailed progress report in 30 days' time and have urged him to assist you with updated facts relating to dates and schedules for the process leading to the commencement of construction. Now, the correspondence continues.
Can I just ask you, when
Yes.
you say that they've put the notice on hold, the service of the notice has brought into being a contract for the purchase of the land at a given price. And by putting it on hold, do you mean that they are not meantime proceeding with the completion of that contract? In other words, the sale itself.
That is right. And the way it was explored in the evidence was simply what had been agreed following the receipt of the first notice, without any specific discussion, cross-examination of whether the effect of the service of that notice was to create an agreement for sale and purchase. And so when I come on to deal with whether in fact that did happen, as I've indicated, our position is that that was not the effect of the notice. But even if we're wrong on that, we would submit that what one takes from the events which occurred immediately afterwards is an agreement, assumption, understanding, implied agreement that the first notice, perhaps we could put it this way, that the first notice, whatever its effect, whether it's a notice to proceed under the option or whether it becomes acceptance of a sale contract, whatever its effect, was not to be taken forward so that the appellants could demonstrate to Vista Del Mar their ability to commence construction.
Yeah, I mean, I'm not sure why we're going through all these documents, because we've got very detailed and helpful agreed findings on this. And the question is, between you, is how you interpret that. And the actual facts, as I understand it, of what was going on are not in dispute, are they?
Well,
I mean, not surprising the parties were looking at this in a practical way of trying to get more time. I mean, I don't suppose they were doing a detailed legal analysis at this stage. And if we've got the facts set out here, I'm not sure why we have to spend so much time going through the documents.
well, I appreciate the indication, thank you.
But
I just thinking in terms of the best way to proceed. So the submission is based on the review of those documents, which were the subject of cross-examination, which the Grand Court judge accepted, amounted to an estoppel in the terms that I contend was the result and the outcome, namely that the appellants are stopped from denying the ability of the respondent to serve another notice, having given them an opportunity to demonstrate that they had the ability to continue.
Yeah, I think I understand what you're arguing, but it's a terribly complicated way of going about things, because you're saying that we served the first notice, both parties agreed effectively to treat it pro non scripto, and we then subsequently were entitled to serve a second notice, which is what we did. But you then, in order to make that good, you have to establish that there was in fact an agreement by both parties or some sort of common understanding sufficient to set up, the way you put it is an estoppel. It'd be much simpler to say that there was service of a notice which brought about the contractual right on your part to purchase and obligation on the part of the other party to sell. You didn't actually proceed to implement the purchase and sale. Meantime, because you were acceding to requests for further time in the hope that matters might be sorted out, but without waiving your accrued right under the first option notice, and provided the delays and so forth weren't such as to prevent you from proceeding to require performance of the contract, there's no problem. And you don't have to establish some sort of agreement by the appellants. But that's a burden you're taking on yourself by the way you're approaching it.
Well, I'm very grateful for that indication, my Lord. I am trying, perhaps going into it in too much detail because of the allegation we face, that the allegations we face in relation to the way in which the Court of Appeal dealt with the estoppel point. And with respect, it's quite right to say at the end of the day, it doesn't matter to Vista Del Mar whether we were right on the cases initially pleaded and addressed, or whether there is some other analysis by which the same conclusion can be reached. Because when we turn to the Court of Appeal's analysis, they essentially said, let's assume that the appellants are correct in their new argument about the effect of serving that first notice. Given what happened afterwards, given what we can see from the correspondence, the outcome is the same, because there was an implied agreement. They said expressly it wasn't express, it was an implied agreement or an understanding meeting all of the tests for estoppel. Either that, as my Lord has said, whatever the effect was, we're simply going back to enforcement of the option.
Yes, but there is one difference, and that is it's enforcement of the first notice, not the second, and your proceedings rely on the second.
I accept that. And that is the pleading point that was mentioned against me. And
but that's all it is. I mean, if there's
yes.
any insistence on it in Court of Appeal, obviously, well, I don't know. But if anybody's troubled by it, all you've got to do is amend your pleading.
That would be right, and if that's what it takes, with respect, then we can seek leave to do that. Mrs. Freeman has reminded me that there was a reference to the earlier notice in our initial statement of claim.
We are, at this stage, we're digging around in pleadings. It seems to be pretty pointless, and we've got set out from paragraph 22 onwards of the agreed statement of facts, the facts which you, between you, have agreed as being the relevant facts. Now, there's no issue about those, and they result from the findings of the Grand Court. What we're trying to do is to interpret them in legal terms, and there seem to be three possible interpretations knocking around. One was the judge's approach of an estoppel, then there's a Court of Appeals of a sort of a common intention estoppel, or estoppel by convention, and then there's one my order's just put to you. And, those are the three as far as I can see, and what we want to know is, which you put your money on and which are your fallbacks and why, but we don't need to spend a lot of time in looking at the documents, I don't think.
Well, thank you, my Lord. With that indication, I'll just move on briefly. I'll move on. Can I briefly say that Vista Del Mar does not accept the suggestion that we spiked the finance application, and that was made this morning, that there was some timing mechanism by which we put in the second notice after we had appreciated that the appellants were about to make an application for funding. That is simply not correct, and it's clear
from... There's no finding of bad faith against you.
Not at all, to the contrary, and thank you, my Lord. So part of the other feature of this correspondence is that although the appellants were saying one thing to us, they were saying another thing to the architect, and they were being told another thing by the bank. And that's why the cross-examination follows that correspondence all the way through. So, if I may just have 1 moment. If it's permitted, the outcome of that examination, cross-examination, is supportive of the way in which the Grand Court resolved the case, and Mrs. Justice Mangatel set out the reasons why she accepted the position on estoppel and forbearance at paragraphs 87 through to 91 of the Grand Court ruling. It may be worth turning to that because it is the subject of comment by the Court of Appeal. This is in Bundle 1 at page 161. At the bottom of the page is the heading Discussion and Analysis of Issue Number 4. There's a reference to the no waiver clause that the court determined Vista Del Mar was entitled to rely upon. No exercise or lack of a right constitutes a waiver by the vendor of any other right or remedy. Further, and in any event, the end date for construction was the 9th of July 2013. I accept the evidence of Vista Del Mar that on the 31st of July it sought an update from the defendants, and on the 2nd of October indicated that it was considering whether to exercise its rights, and she goes on to conclude that Vista Del Mar acted reasonably and promptly. She refers to some of the correspondence. And then she says, finds it, paragraph 89, the evidence clearly demonstrates that Vista Del Mar in good faith, based upon the defendant's continuing assurance that they would soon start construction and request for understanding and forbearance, did not act upon the timetable referred to in its notice.
And 91 is probably...
Yes,
Your point of view.
from my point of view. So and a reference there at the end to the no waiver clause. So if one accepts that that is the right way of looking at things, then we say it amounts to an answer available to the board as well. If we could then turn to what faced the Court of Appeal, which is in the same bundle, back at page 41. And at paragraph 26. Paragraph 26 sets out the argument. Paragraph 27, the failure to complete within the 30-day period specified in the first notice was an abandonment of that part of the agreement for sale that obliged the appellants to construct a residence on the property. Now, I've addressed that by pointing out that the 30-day period was an expression of intention, not a strict time period. And there is the paragraph at 28, which my learned friend complains about, but it is clear that that's indeed what the appellants were suggesting had happened.
Well, there's also an important point made in paragraph 30 in the first sentence, because which is the best analysis is going to depend on what the facts were. And the point's made there that the argument being presented by Mr. Robinson in the Court of Appeal, that following receipt of a 14th October notice, the parties moved out of the territory of option and into the territory of a contract of sale. In other words, that the service of the notice brought into being a contract of sale was not a point he took at trial.
Precisely, my lord. So that's why we developed into a discussion within the transcript of the Court of Appeal, essentially with the Court of Appeal saying, well, let's assume that an agreement for sale was the right analysis rather than an exercise of the option. What was the effect on that agreement for sale, having regard to the correspondence between the time of the first notice and the time of the second notice? And the conclusion reached is that the effect would be the same, because there was an implied agreement, assumption or understanding that the respondent would not be prevented from calling those discussions, negotiations to an end and proceeding to enforce its option.
If there was an exercise of the option in October 2013, what was the obligation about delay after the exercise of the option?
Because the terms of the agreement did not specify any particular time by which the agreement had to be completed, the new agreement had to be completed, it had to be completed within a reasonable time. The reference in the letter to an intention to try and achieve that was within 30 days, did not set a hard deadline. The court is still entitled to look at what happened next, and then we go off onto a tangent because of the discussions which ensued.
But it may not be as strict an obligation as complying with time for the exercise.
Yes.
All the circumstances, with respect, all the circumstances can be taken into account.
At that point, if there is actually at that point an agreement, a contract between them for the sale of the property back to Vista Del Mar, aren't you into the territory of specific performance? In which case you're just looking at whether the delay has been unreasonable in all the circumstances. And then you take into account all the exchanges between the parties.
I believe that's right. I believe the relief being sought would be the same when you look at the way in which we were seeking the enforcement of the option.
But you, by that analysis, you avoid all the complexities of estoppel and technicalities of estoppel by convention and so on. So it is important to get the analysis correct, perhaps.
Yes, I accept that, and what I was proposing to do was to try to justify my submission that, contrary to the argument taken in the Court of Appeal and perhaps contrary to one's natural inclination on the board, the relationship did not change to that of vendor and purchaser. And obviously we have the point that no finding has yet been made to that effect, because it was raised late. The point was not raised in the Grand Court directly. It has not been the subject of determination in the Court of Appeal. And what we say is that in the circumstances of this case, that contract for sale argument is not one that should be automatically, sorry, the contract for sale, vendor-purchaser switch, the switch from being an optionee to a purchaser, did not come about automatically by the service of the first notice, by virtue of its terms, which expressed an intention over the next 30 days and a discussion as to how the transfer and the extinguishment of the agreement for sale and the deed was going to be put into effect. I think.
Do we see it in relation to the second notice at 790?
Yes, we do. The second notice has the same language and refers to the more recent correspondence.
But then we see the proposed deed, don't we?
The proposed deed is subsequently sent out, yes.
Those would be matters of mechanics, wouldn't they, the matters that were left outstanding?
Well, it is tempting to say that, but I think my strongest point is that the mechanics in this case included determining what the purchase price was. It wasn't simply the amount we paid. It depended also.
Ascertainable. You could find the purchase price was ascertainable.
I agree with that.
So, I mean, you know, I'm very worried about sort of being forced to construe a perfectly straightforward notice, which may well apply in other cases. When, I mean, the only point you're being driven to make these submissions is you're worried about the pleading point. And the simple answer to that is to amend your pleading. I mean, you haven't asked us to do it, but I don't. We obviously have to see what the other side said. But
Well, you had asked us, actually.
Well, I'm asking now, if I didn't make it clear earlier, if that is an acceptable way of proceeding and one way through it, then.
because as I said, you've got these various different ways of putting it, but in your submission, they all come to much the same thing. You allowed some forbearance, and that resulted, and you decided to do it by second notice. So whether that had an effect is, in a sense, neither here nor there, you would say.
Well, do you want to take a minute or two to consider what amendment precisely you would like to make?
Yes, I would need to take some.
And then if you can notify counsel for the appellants of the amendment, they can then decide whether they wish to oppose it or not.
Yes.
Well, if we'll rise for 10 minutes. If you're ready before that, let us know. But we'll allow you 10 minutes.
Very grateful for the additional time to complete a difficult textbook examination on pleading. I've done my best to do as little damage to the current pleadings as possible. I've had an opportunity briefly to talk to my learned friend, who is not in a position to agree anything. And it's not clear to Mrs. Freeman and I whether I have understood exactly what my lords and ladies were driving at. However, my suggestion would be as follows.
Well, it is your pleading, it's not ours.
If the board could please take up the statement of claim in Core Bundle 3, page 670. At the top of 670 is a heading particulars that can be crossed out. I think that was just an error. And paragraph 13 would then be amended. Actually, sorry, just before I do that, over the page on paragraph 12, sorry, on page 669 at the bottom of the page, it says, at various times between the 2nd October 2013 and the date of commencement of this action, the plaintiff reserved its rights to exercise its right to repurchase the property pursuant to clause 2.1 of the deed of variation. We then delete the reference to particulars, and paragraph 13 is then amended to say as follows. This is a new start to the sentence. On 13 October 2013, the plaintiff sent a first notice to the defendants, and by this point we're back to the start of the original sentence. And on 10 July 2014, the plaintiff sent a second notice to the defendants, exercising its right to repurchase the property. Paragraph 14 remains the same. That refers to receipt of the notice and reference to the discussions and communications that took place thereafter. And a new paragraph 15 could then be inserted to say, in the circumstances, an implied agreement or assumption or understanding was reached between the parties that the plaintiff was not prevented from serving the second notice if the defendants could not demonstrate their readiness to commence construction.
Could you just read paragraph, the new 15 again?
In the circumstances, an implied agreement or assumption or understanding was reached between the parties that the plaintiff was not to be prevented from serving the second notice if if the defendants were unable to demonstrate their ability to commence, their readiness to commence construction.
Is that the end of the paragraph?
Yes.
Don't you need to say that if the second notice was if the first notice was effective, the second notice would be ineffective?
Yes.
Something to that effect?
Yes.
Because what you've done is plead in that sentence the convention estoppel. Well, no, that wasn't drafting, but
Well, I was going on to.
I thought that's what you were putting to us, was that you would argue that if it was necessary to do so, if the first notice was a valid one, that the second notice did not prevent it from remaining valid.
So. Now, I think I then need to go on to say...
You've lost your audience.
Hopefully they think I'm Australian. I believe it would be prudent to go on to say in a new paragraph, further or alternatively, any agreement for sale and purchase coming into existence as a result of the service of the first notice was similarly subject to a stay or delay by way of estoppel by convention. And then another paragraph, further or alternatively, effective service of the first notice was to create a binding contract of sale enforceable by way of specific performance. So with apologies for drafting that.
Yeah, can I just check I've got it down correctly? So in paragraph 13, on 13th October 2013, the plaintiff sent a first notice to the defendants and then we read on as per the existing pleading, but insert second before notice.
Yes, and I think it should be defendants.
Yeah. Then 15, in the circumstances, an implied agreement or assumption or understanding was reached between the parties that the plaintiff was not to be prevented from serving a second notice if the defendants were unable to demonstrate their readiness to commence construction. Further or alternatively, I'm not sure I've got this down quite right, any agreement for sale and purchase coming into existence as a result of service of the first notice was similarly subject to a stay by way of estoppel.
Yes, I think I said stay or delay.
A stay or delay.
By way of estoppel by convention.
By estoppel by convention. Further or alternatively, the effect of service of the first notice was to create a binding contract of sale enforceable by specific performance.
Yes, except that I think it would be prudent to adopt the suggestion that a further sentence be added to the new paragraph 15.
Yes.
To the effect that it's an alternative pleading that if the first notice remained effective, the second notice was ineffective.
Didn't prevent it from remaining so, I think, was what you said to us.
I'm obliged, my Lord.
If the first notice was effective, the second notice did not prevent it from remaining so.
The second notice did not impact on the first notice. Didn't prevent the first notice from being effective. And that preserves the right to proceed on the alternative ground of the coming into existence of a sale and purchase agreement.
Yes. Yes, well, I think we'd better hear from the appellants in respect of your motion for leave to amend.
First point is that, the first point is that I thought that the only thing that was being suggested, or the only judicious encouragement being given, was for the last element of this, that there should be an allegation contrary to the respondent's case up to this hour, that there was a contract brought into effect by the service of the first notice, which remains valid and enforceable. I thought that that was what my learned friend had actually put his mind, as it were. Instead, what we have...
I mean, would you object to that?
Um,
Because in effect, that's what the judge found. It's not what the Court of Appeal found, but it's what the judge found.
Well, would I object to that? And my holding position is yes, because this has just come out.
Yeah.
What is going to happen next? I mean, one wouldn't contemplate giving leave to amend, entering judgment on an amendment instanter. We would have to have time to consider it. I mean, all of our team are lawyers, of course, but we've only just heard this. And besides that, there is inevitably an issue of costs, because if they succeed on this amendment, it's an amendment made at the last possible stage.
But we would deal with costs after any judgment had been, any decision had been reached.
Well, I must have some opportunity to be able to consider our position in light of this complete change of direction.
What obviously is being sought to be done is to bring the pleadings into line. Well, if the first part of the proposed new 15 is to bring the pleadings into line with the Court of Appeal's approach, and the last sentence is designed to bring the pleadings into line with the judge's approach.
Well, this has not been the respondent's approach up to now, because the substance of this is that one is relying on an agreement having come into effect in consequence of the 2013 notice. I think I ought to just show you two things before we carry on. If your lordships would look at the respondent's case at paragraph 34.1.
Which paragraphs, please?
34.1, it's 1622.
Thank you.
I think my learned friend did make reference to this. This was what is in their case in response to our allegation that they didn't rely on the first notice but on the second notice. You can ignore the first sentence. Here, the conversion of the option to a sale and purchase agreement never took place because immediately after the first notice was sent, the appellants requested forbearance on any enforcement action, and agreement was reached that the enforcement would not proceed before meetings and discussions took place. And then he says, in any event, there was paragraph 12, but it doesn't stop there. If you take up bundle 1, and go to page 113. This is what I made reference to earlier, that there was earlier, I thought this was a reference to making an amendment in the Court of Appeal, which wasn't taken up. It doesn't quite go that far, but it's important, I think, for your lordships to see it. Page 113. Learned friends asked by the Honourable John Martin, factor in the argument that we're not in the realm of option at all, and now there is a new contract for sale and purpose. Again, Ms. Francis comes to you and says, I know that I'm now contractually bound to sell to you, but please will you agree that I don't have to? I'm trying to work out what you actually say was the effect of negotiation which undoubtedly happened, and which she undoubtedly asked for forbearance, and which you gave it. But just saying there was forbearance doesn't seem to me to go far enough. And then my learned friend responds to that. And then the judge says, well, there's a difference, I think, because on the first analysis, if you're looking on the option, then the way we've looked at it so far, the right is preserved to give a new notice. But if you look at it in the terms that you've just been saying under the contract, you're stuck with a contract having arisen in whatever it was, October 13th. And now you're looking at the slightly different question of whether it can be said that the time for completion has been extended by agreement. And my learned friend responds to that, and then over the page the judge says, it would not only have some value, it would be the foundation of your claim, and that is only a pleading point, but not nevertheless a point, yes. That you may, if that's the correct analysis, have chosen the wrong notice to found your case. And then my learned friend take the point that wasn't, he says that wasn't taken at the hearing, that it was being approached by the option route by the judge, and so forth. If your lordships would also look back at page 111. The judge then put, from the middle of the page down, the judge then put this to my learned friend. You presumably wouldn't disagree with the basic proposition that leaving everything outside of the whatever it was, this option can only be exercised once. Yes, that is right. With respect, yes. So on the footing that the notice in October 13 was a valid notice, that's your one shot on the face of it. Yes. But then he says one is entitled and one must look at the conduct of the parties. So there was an express disavowal of what is now being proposed by way of amendment.
Am I right in thinking it was your case that there was a contract that came into being with the service of the first notice, but you coupled it with the time is of the essence point?
Yes.
You lost the time is of the essence point, but nonetheless your analysis that you were putting forward was there was a contract.
That was part of our case, yes.
Yeah.
Yeah.
So the amendment is to plead what was your case?
No. Well,
In part.
I think our position is that they disavowed this. They disavowed our suggestion now. And the analysis was really quite different because the context was really quite different. There were a lot of other allegations that had to be dealt with. So if you are minded to allow the amendment that has been proposed, then there seem to be two possibilities. One, unattractive as it may sound, but consistent with what happened in the Singh case, is that you remit this to the Grand Court for further proceedings consistent with the amended pleading. And that will involve a responsive pleading from us at some stage. And I can't say at this stage what that is going to say. And the other is so far as the costs of this exercise are concerned. Now, those, of course, can be dealt with on paper. But it's well-established principle that if an amendment is allowed at a stage as late as this, then it's going to have cost consequences for the proceedings below and these proceedings. And we would want to address you, certainly, on that, because that has now very, very significant practical implications. I don't think I can take it any further from there, unless you wish me to deal with any specific you have in mind.
Would you wish, if we were to allow leave to amend, would you wish an opportunity after this hearing to put in further written submissions if anything were to occur to you as being worth adding to your existing submissions in the light of the amendment?
Well, yes, I'm sure we would wish to do that. May I just take instruction?
Yeah. Yes.
Unless I can assist any further.
No, thank you very much, Mr. De La Rosa. I think we will adjourn for perhaps 2 minutes just to briefly consider where we are in relation to the amendment, and then we'll resume. What we're going to do is this. We will complete the argument today on the unamended pleadings, so we'll hear anything more that you have to say in relation to those, and hear Mr. De La Rosa's reply. Obviously, we have heard what your proposed amendment is, and we have heard argument on it, but we think it would be better if you were to put in writing an application for leave to amend. The appellants equally can put in any application that they might have to amend in response if the amendment is allowed, together with any further submissions you wish to make in relation either to whether we should allow the amendment or the position in the event that the amendment is allowed. Other than costs, they can be dealt with as a separate chapter once the merits of the appeal have been decided. Is that clear enough to you all?
Yes, my Lord.
Thank you.
I'm obliged. To finish the submissions in relation to estoppel, I was simply going to draw the board's attention to paragraphs 41 to 65 of the respondent's written case. And we've dealt with the pleadings point, the cross-examination point, and to some extent the point on whether there was sufficient evidence for the Court of Appeal's conclusion. Just while I'm there, in answer to my Lord Kitchen's question in relation to paragraph 50.3, page 1635.
Yes.
The reference for that statement is the Court of Appeal transcript bundle, which is bundle 1, page 79, lines 1082 to 1090. That is part of the new argument that was raised in the Court of Appeal as to what was going on after the first notice was served as it pertained to the enforcement of the alleged agreement for sale of land that came into effect. The reference for the abandonment of the affirmation point is found at paragraph 42 of the respondent's written case on page 1632, where we have referred back to the reference in the Grand Court ruling and the place at the transcript at which that abandonment or withdrawal was made. One, 263. Oh, sorry, 163. And I perceive all of that is relevant to the point we were just discussing about the pleading and the way in which the case shifted in the Court of Appeal to the issues before us today.
How much more do you need to address us on, Mr. Imrie?
Just the unclean hands point.
Fine.
What?
So I'm anxious that Mr. De La Rosa should have adequate time to reply.
Thank you, my Lord. I have set out some legal requirements from paragraphs 54 through to 65 of my submissions. The one point I would emphasise in response to something my learned friend submitted earlier was that there's some room for debate on how unequivocal the agreement needs to be, and that's the subject of the cases referred to in my submissions. The terms, we say, must be interpreted by the court, and the true meaning is decided upon by the court. That's paragraph 57. Against that background, I was going to turn to the topic of unclean hands and deal with that in the following way. Firstly, the appeal was opened this morning on the basis that Vista Del Mar had acted in a selective and discriminating manner towards the appellants, and in particular that they were the only party against whom proceedings to enforce the option had been taken. We strongly reject the allegation of being selective and discriminating, for in order to make that allegation, one must overlook the content of the reproduced record bundle number 5. And if the board could please take up bundle 5. One sees at page 1264, at the start of the bundle, a deed of release and settlement. Now that has been redacted to take out the names of the individuals who were subject to the deed. The reason for that is that it contains a confidentiality clause. It was produced in the proceedings pursuant to a series of orders and agreements made with the opponents as to how information about other owners was to be disclosed. But that was the first exercise of the option by way of deed and release. And at page 1272, the second exercise of an option by way of deed and release is included. And so we say with respect that there is evidence before the court of Vista Del Mar enforcing its rights under clause 6.2 against other...
We got findings about that, haven't we? We got the findings of the Grand Court about that.
Yes. And what one also sees in the pages which follow are many pages of correspondence written to different owners at different times, insisting on compliance with the obligations to commence and complete construction. And whilst it is true to say that the appellants are the only parties against whom proceedings have had to be commenced, it should be clear from that correspondence, considered both by the Grand Court and the Court of Appeal, that there has been no selective or discriminatory practices here. Vista Del Mar has insisted that the development be completed in the manner contended for in Mr. Joseph's affidavit. I should also draw the court's attention to page 1297. Now, this is a table prepared by Mr. Joseph, referred to in evidence, that responds to the evidence given by Ms. Francis and the table which my learned friend took the board to this morning. Because Mr. Joseph gave evidence that was accepted, that in respect of the allegations made of selective and discriminatory conduct, Vista Del Mar had followed up and taken action against each of the other owners in the manner set out in this table, either causing completion of the property, perhaps pursuant to an extension of time or otherwise, either having the property sold to a third party in accordance with the terms of the agreement for sale, or extending the time to enable completion to be made pursuant to a formal extension or side letter.
Mr. Emery, I think I'm going to have to ask you to come to a close, because we do have to let Mr. De La Rosa reply, and we do have quite full written submissions from you on this point of clean hands.
Thank you, my Lord. I was just going to say that everything else that I would say is set out at the end of my written submissions.
Well, that's very satisfactory then.
Unless there are any other questions, I think I can.
Thank you very much.
Lords, my learned friend started his submissions by referring to what he said was a concession by Mr. Robinson, which he referred to at page 53 of Bundle 1, between lines 289 and 337. If your Lordships would turn up that page, this is, again, part of the Court of Appeal transcript.
Yes.
And if there was any concession, and we don't think that there was in this regard, this must be what the learned friend is thinking about. Page 53, he mentioned page 289, but you have to start at 283. There are two potential opportunities, my Lord, under the terms of two potentials. First, if construction does not commence, and now if construction commences, the judge says when, at any time. The appellants had 18 months within which to complete construction, and if they failed to complete construction within 18 months, the second opportunity arises. Well, if that is right, then it means that the vendor has in principle had two possible occasions. The fact that he didn't take the first of those occasions, i.e., if he didn't take the first of those occasions, he doesn't lose the right to take the second if it arises. If it arises. Well, if it arises depends on the emphasis you put on the word such construction. As you say, to complete such construction means construction that is started at some point. And Mr. Robbins says correct. They go on to discuss those terms again. At the top of the next page, the judge says, so it is intended that such construction means construction that has commenced. Yes, my Lord, that is my submission. It is construction that has commenced. And in the context of the document, which I consider to be important, includes Clause 5, which speaks specifically to completion of construction within 18 months. So that leads, my Lord, to an interpretation whereby one can see that the intention was, one, to limit the time within construction must commence, and secondly, where construction has commenced, to limit the time of the duration. Well, in my respectful submission, that's not really a concession of anything. It's simply a recognition that there might have been two trigger points, and that it would depend on the circumstances when the respondent exercised the option. Now, all of this may turn out to be academic if the respondent's primary case is amended, but there's no concession here. Can I turn then to, as a preliminary matter, to an inquiry that Milady made about an email in the bundle. This is the June email. The email is actually at page 770. But you need, for the background, to look at paragraph 20 of Janet Francis's witness statement, which is at pages 310 to 311. Now, my learned friend referred to the fact that he read some correspondence earlier today, and he went to paragraph 12 of Mrs. Francis's witness statement, which refers to the illness of her mother, and referred to the respondent being sympathetic and understanding as a result of learning of the death of Mrs. Francis's mother. The problem is that that case isn't consistent with what we know with the background documents. We know that the respondents weren't on notice of Miss Francis's mother's illness. They weren't even on notice of her death until after it took place in April of 2013. And some of the correspondence my learned friend took you to shows that quite clearly. If you bear with me for a moment, I will turn up the... Where is it? It's an email which I think your lordships have seen, which is in October of 2013. Page 745. of October 2013. Referring to an email message of October the 2nd. For the most part, and then the second paragraph, for the most part, our exchanges regarding our progress have been in writing, although our more recent communications have been less formal, via telephone conversations with Cindy. I felt it would be far better to write, essentially. That said, VDM would not have been aware of the more recent developments as I have been traveling over the last few months in order to attend to some unexpected crises which required that I be off island. So it wasn't until after this point that VDM was notified of Miss Francis's death. Now, it's a small point, but it's being represented, and given the lapse of time, maybe it's understandable, but it's being represented that VDM stayed its hand out of sympathy for Miss Francis. Well, the reality is really quite different. They weren't aware of the situation until she told them, and that was after the point at which they'd served the first notice. The only other point which I want to deal with, and I think I can deal with this quite shortly, is the correspondence that you've been shown passing between the parties in the wake of the service of the two notices. And our primary submission in relation to that is that it simply doesn't get the respondent home on the basis of estoppel by convention. What it shows is that quite properly, quite politely, Miss Francis and Miss Clark expressed some appreciation for what the respondent itself has described as forbearance. But what that meant for the future is nowhere expressly defined. And again, we have no evidence of a common understanding of the kind that one needs to found an estoppel by convention. So none of that correspondence taken as a whole really gets the respondent home on the estoppel by convention point. I'm invited to give you one other reference on the penultimate point that I made, which is to page 325, and that is Mr. Joseph's witness statement at paragraph 9, and I think this is what my learned friend was referring to. When Miss Francis' mother passed away, VDM was very sympathetic, and this was naturally accepted as a reasonable cause for delay during that period. However, incorrect defendants to cite Mrs. Francis's mother's passing at paragraph 12 of the Francis statement as the reason why the defendants did not progress construction plans between April 2013 and January 2014. Well, bear in mind that they simply did not know at that stage what the position was with respect to Miss Francis's mother. Now, I'm perfectly happy to deal with any question from any quarter if there's anything that...
No, I don't think we have any questions for you.
I'm very disappointed at that. But that goes with the territory, as they say. Well, thank you very much.
Well, thank you both. If we were to ask you, Mr. Rimmery, to provide us with your application for leave to amend with any supporting submissions within 7 days,
Yes, my lord.
and then allow a further 7 days for a response by the appellants?
Yes.
Very well. What we'll do then is we'll await that material. The board will then decide whether to allow the amendment and any further amendment. And in the light of what we've heard today and any further written submissions, I imagine that we'll then proceed to consider what advice to tender to Her Majesty. Well, we're most grateful to all counsel and to those sitting behind them who've been also, no doubt, involved in preparing these cases. Thank you all very much, and you'll hear, no doubt, in the normal way what the decision finally is.